for Tuesday, January the 2nd to order. Start out with general business, ordinances online. Michael?
Thank you, Danielle.
Okay. There was some feedback in here or something.
His mic or something, I don't know what it is.
Yeah, I don't know what was going on. It was mentioned at a previous board meeting about looking at the ordinances in which are currently have been adopted, and to review those and talk about those that may be outdated or need some updating or deletion altogether. And I believe Commissioner John Irwin, you had brought the topic up and asked for it to be on today's work session along with some other items. So in an effort to provide the information, instead of printing out all 70-some plus of those ordinances that are out there, you were provided that link, and I'm sure you've all read every word of all 70 of those ordinances, and we're probably ready to talk about those today. And with that in mind, I think perhaps since Commissioner John Irwin brought it up, maybe start with him and let him lead into the dialogue.
Thank you, Mr. Chairman, County Manager. The first one that I would like us to look at is an ordinance regulating the disposing of trash and solid waste in roadside containers. This goes back to 1974. We don't have any roadside containers.
Which one is that 148? 1-48, 1970?
I printed them off. I'll just have to go by what's on there. It says an ordinance regulating the depositing of garbage and solid waste in roadside containers.
Okay, I got it.
Since we don't have any roadside containers, we can delete that one. If we remove that ordinance, we can also remove the ordinance where it corrected the article that was cited in the original ordinance. That would be an amendment, Danielle.
May I ask, when was this one adopted? Does it have a
1974.
74?
If you go on down in the bottom, January the 7th, 1974, 50 years ago. Now, if we started doing roadside containers, we wouldn't have to worry about people complaining about being charged for not being using the transfer station that they can't use because they're only up here on the weekends. The next one.
So are we, may I just clarify something? So
It's just my recommendation that we remove it.
and we're going to note that for a future board meeting.
Yes.
So with each individual's ordinance or ordinances that they want to discuss, I'm guessing that the recommendation for, in this example, to delete it would also be something that the board talks about before moving on to the next one, and that way it doesn't get so cluttered. That would be,
I've got about 12.
okay.
Talk about that one.
I think you take them individually.
I'm good with that. His recommendation.
With it.
With it.
Well, just a minute.
150.
what are we looking to do away with some of these ordinances?
Yes, sir.
They're no longer applicable.
Guess I've got a question about our rules of procedure, rule number 25. Should be in your packet. I want to be sure that I understand Rule 25.
The rules of procedure only apply to open meetings and/or closed meetings, correct? Okay.
Yeah, number 25.
So what's your question?
What's the process that we have to go through? Is any of this open to public comments? That's one question. Then it says, must be approved by all members of the board. It doesn't say a majority. It says all.
Goes in the next sentence.
Pardon me.
It mentions a majority in the next sentence.
I'm just asking for clarification. Can we go ahead and do away without an ordinance, without going through it, and without having any type of public notice?
We're not asking to do that. We're just bringing attention to the
Yeah.
need to be looked at.
Just discussion right now.
No, it's just a discussion, but if we get to a point we want to do away with an ordinance, what would the process be?
If you're talking about these ordinances today at a work session, and if the thought process is to take whatever considerations or discussions are here today to a future board meeting, my interpretation would be that item no longer is in an informational setting because you've talked about it in a work session. That item would go straight to an action item. Now, if you read these rules, it does say if the proposed measure must be approved by all members of the Board of Commissioners. That sentence says that. Right beside it, it says if the proposed measure is approved by the majority of those voting, but not all of the members, or if the measure is not voted on at the meeting where introduced. Well, you can't vote on it today because this is a work session. It shall be considered at the next regular meeting of the board. So Heather is the interpreter, but to me, that just says that if it's not approved by the majority of the board, there is a way, for all board members, there is a way for that item to make it to the agenda by the majority of the board and then voted on accordingly. Now, I'll defer to Heather.
Or it could be that if you look at it, that it would be, if you don't have everybody voting on it for it to be adopted or removed, then you could move it to another meeting where you could reconsider and then have everybody vote again to see if you can get everybody to vote, but then maybe it's not everybody, because now it says just a majority. Or is it a majority to move it?
So it would go back to being a majority, not all members.
Well, but I think it's a little confusing because it's saying you need everybody to vote on it, but then it makes it appear like if you had a majority to vote, you could move it to another meeting where you could reconsider it. But does that bring it back to having all of the board vote for it? Or is, at that point, if you had to move it to another meeting by majority vote, now is it just majority?
It does say, but not by all members of the board, so I guess it does have to be, then it goes back to another vote. So I guess until everybody votes to take the same action, it has to keep coming back, or
By a majority
nothing
vote,
happens
or
to
you
it.
just
Yes,
forget it and leave it off, and just, it dies because you don't have everybody agreeing to vote.
right.
That could be the interpretation of what that rule means. So it needs to be unanimous. By a majority, you could move it to one meeting or the other, but I think it's unanimous that it would be that you would approve or disapprove. Vote for it to be removed or vote for it to be added, or vice versa.
I just got confused.
It is
I think part
confusing.
of it by all.
It is confusing.
I've only heard of all members having to vote for something, one thing. That was a DOT situation, that it had to be unanimous. Then I look at Rule 17. A motion shall be adopted if approved by a majority of the votes cast, a quorum being present, unless these rules or the laws of North Carolina require an extraordinary majority. I just go back to, we've had this problem once before, where it has to be unanimous.
Well, you also have on the agenda, I think, today, looking at your rules.
Yes.
So if that is confusing and you wish to change that rule to clarify it a bit,
Why would, just for question, each elected official has a different mindset about a different issue. Why would it take a unanimous vote to do any of this, when in any other situation, minus what you just mentioned, why in the world would it take a unanimous vote to include, add, amend, or, why would that happen?
Everything we do is based on a majority of the votes, 3-2 or whatever. That's why I just asked that question.
well, I think for argument's sake right now, we don't worry about that, but when you come to actually looking at your rules, we bring that up again, and that would be one that potentially you would change so that it doesn't have all in there. It would be majority, and that clarifies that situation completely under Rule 25.
That's something we as a board can change.
It's your rules.
Okay.
So with that in mind, if we go back to the ordinance, is it safe to assume at this point that everybody is okay with the recommendation from Commissioner John on removing that ordinance? And that is impacted by something we'll talk about later with your rules of procedure.
I'm fine.
Let's keep going.
The next one is the ordinance for the regulation of mass gatherings in Alleghany County. My question there is, are we enforcing? Is the health department issuing permits for Fiddler's Convention? Anything that attracts over 300 at the fairgrounds? Music on Main. Here again, oddly enough, this is February of 1975. Yes, 1775. But on September the 11th, 2001, this comes in,
And then COVID.
COVID.
That's the only time I know that there's been some type of, and I wouldn't even call it enforcement, I would call it more of encouragement.
Yes.
We shut down the motels, bread and breakfast, things of this nature. But this has been on the books for 49 years, and I don't know if we're enforcing it.
Well, at each individual event, so at the fairgrounds or even Music on Main or things like that, they've got an event type insurance that they get specifically for that event. So that's not coming from the health department, that's just something that they get themselves for an event.
The intent and purpose of this ordinance is to provide for the protection of public health, welfare, and safety of those persons in attendance at mass gatherings. So this is why the health department's got to issue the permit. They're supposed to be going over there to make sure if there is sufficient bathrooms for the number of people that are showing up. The question is Parks and Recreation enforcing this? Because they handle the fairgrounds. Is Music on Main, which they tell us is showing up 800, are they getting a permit from the health department? Is the health department looking at this?
I've never heard of that for any event. I think even for the Music on Main, not Music on Main, but,
Schools are exempt.
yeah, but even if you're talking about Heritage Festival, they're not. Health Department may come by and inspect individual food providers, but they're not issuing a permit to the town, the county, the chamber that I know of. Bob, you ever heard of that for any?
We have an
Last year,
ordinance.
I was told that this ordinance was put in place to stop, Dave Sturgill out in Piney Creek, who was the guy who did the music thing, he proposed having some sort of, something like a country Woodstock, and people were aghast at that, and they put this in to make it so difficult, so they wouldn't have that. So that's what I've been told. The purpose of this thing was not to protect the health, but was to squash that event.
An application for a permit for a mass gathering shall be made to the county health director on a form and in a manner prescribed by him, by the person who will organize, sponsor, or hold the mass gathering.
I don't know that it's ever been executed.
What number is this on our ordinance?
On that list, it would be 1-29, 1975. On page 2 that I printed for you.
1-29, yeah, I got it.
Yeah.
If you scroll back, it mentions something about the school system. They're not included.
That's correct.
Is that because they own the building or the property? Or
This
is it
is under
because
a
it's just a
state
school?
statute. This is under a state statute, and the state statute states that it doesn't apply to schools. I
What
mean,
if we as a county own the property? Does that change the school system, being able to gather those people? When the school system borrows money, we put it up for collateral, and it goes into our name, comes out of the school system's name. How does that apply to these schools with this ordinance?
Don't know.
I'd have to look at what the statute is that potentially is regulating this, if it's still applicable or not. And if it's not applicable, then I don't think it's going to affect anything for the schools. It really just depends on what the underlying statute for this particular situation would be. I don't even,
Article 28, Chapter 130 of General Statutes of North Carolina.
It may be, because you can't necessarily look at this as just something that happens in Alleghany. It may be that the state does want to regulate large events itself statutorily, so that's something I have to look at to figure out, is the state still regulating that and requiring there to be permits? We might not have any choice if, John, did you look at the statute on that?
I glanced over it. I did not read it in detail because it was referencing also the general statute, and the ordinance requires that if you reach a certain number, you must have a performance bond or other surety to be executed to the county in the amount of $5,000 for up to 10,000 persons and 1,000 for each additional 5,000. So there's a performance bond that is also mandated by our ordinance. And I have a feeling that that's in the state ordinance, because where would we come up with that figure? $5,000 in 1975 was money.
This is a 1975 regulation, and it's based basically, John, on state statute.
Yes.
Has there been any amendments to that statute since 1975? They amend these statutes quite regularly. This applies only to property that the county owns?
No.
Any,
property, except for school.
Gathering of 300 or more.
so the country clubs that have more than 300 people?
Roaring Gap at their July the 4th party,
What about
they should
churches?
have a health permit.
What about churches?
You know, if we aren't enforcing it, I have it.
I know in my 7 years of the chamber, we never enforced
I can understand the health aspects of it, because if you've got a mass gathering, if somebody's got diarrhea to you gag or something like that, it could spread. The classic example is COVID.
What about a parade?
If it's going to be, well, it says, mass gatherings means the congregation or assembly in which admission is charged in reasonable contemplation of profit of more than 300 people for a continuous period of more than 6 hours in an open space or open air. Now, your Fiddler's Convention falls right in there. Are they getting a health permit? Are they even aware? Is our Parks and Recreation Department aware that under this ordinance, they've got to get a health permit?
Just filling out the application.
A mass gathering in a permanent building or structure shall include only those assemblies which, by reason of their size, the county health director determines to be likely to pose a threat to health, safety, or welfare through unsatisfactory provision of adequate public safety, fire, sanitary facilities. It's a $50 fine if they break it. I would suggest that we advise our Parks and Recreation Department that if they anticipate more than 300, that they tell them to go to the health department and make sure they get a permit. It's mandated by state law, and we are not enforcing it. We're going against state statute.
one thing, I just think we need to be sure this is a current
Need to be updated.
law.
There's going to be a lot of quietness in this room if every time we get to an ordinance, 5 heads look over to this side of the room, and Heather and I are over here playing on the phone.
Well, I'm not playing. I'm trying to
I'm
look up
just-
the statute to figure out, is it still valid? Does that still apply?
When I say playing, I'm saying that we're working, trying to answer your question. I'm not saying that we're just over here twiddling. But what I'm getting to is with each ordinance that comes up in today's discussion, we can dissect these things all we want. Today, in my mind, is just to identify these ordinances that are questionable or maybe not permittable any longer. And if the board together feels like that this is something that we should, it doesn't say we have to do it at the next meeting, we can do it at a future meeting. Give us the nod, yes or no, that you want to either, what direction you want to go on these things, and then we can do the necessary homework to get you lined up with how you go about doing it. But we're gonna sit here for, an hour and a half in silence listening for the crickets because these are questions that we just don't have in front of us that we can answer.
And that's my question. Is the Parks and Recreation asking for a permit whenever they are assembling over 300 people?
I know.
Then we need to make them aware of that. And if we go to the health department, they're going to look at us and say, what the devil are you sending them over here for? We've never done this before.
And you're going to be viewed as trying to stop gatherings of those type of, because if the health department says we don't have time to do it, and that's one of the checklists that you have to have before you can have it, you've suddenly killed that opportunity.
But referencing a North Carolina statute, if that statute's still in force, should we not be enforcing it? If you ask the legislature, they're going to say, we passed a law, we expect you to enforce it. But here again, we've got an ordinance that hadn't been looked at basically in 49 years. Here's another one. I can't tell you which one this will be, Danielle. Be it enacted that householders who list household property for taxes in Alleghany County may list 10% of the tax value of their residence. Is that still in effect? I think Rita ought to review that and advise us, because I don't believe it is. And there's another one later on that I'm going to bring up where she's supposed to be charging $10 a vehicle on property tax. I don't believe that's happening. But we've got an ordinance.
Or per vehicle go in effect.
Let me get to it.
Something in
This one
Bristol.
was 3 November 1975.
I think somebody needs to look at these ordinances and see if they need to be, one person look at them, done away with, or
Is that a consensus to have Rita look at that ordinance and advise us if it's still in effect or not?
Yeah.
And if it's not in effect, how was it removed? Because there's not an ordinance removing it. Here's another one. Ordinance for the regulation and control of telephonic alarm systems. This is where if you've got to have an annual permit, which costs $15, make application to the Board of County Commissioners for the license to put in an alarm. If you have a false alarm, you're supposed to be fined $15 a false alarm. We aren't doing that. Why do we need it?
This one is an old one, but I think it comes from the fact that in older homes, and I can tell you this because this happened, we had it, you used to have a box for a security system, and right beside that box was a direct dialer for when the alarm went off, it clicked the dialer off where it would dial the sheriff's department, because at that point you didn't have 911. It would call the sheriff's department or the fire department or whatever to have them come out and check on the fact that your alarm just went off.
And it happens, go to your dispatch. Whenever I was working dispatch, we had at least one a week.
So I think they were trying to say if you have that problem and yours just goes off randomly and there's no problem, you need to pay for the fact that the services came out to check on your property. Today, that's, I don't.
Application for permit.
understand.
Application for permits to install, maintain, or operate a telephonic alarm system which is intended to automatically transmit a signal, message, or warning to any emergency dispatch center telephone line shall be filed with the Alleghany Emergency Services Board or its designated representative. Forms supplied by the board, $15 a year. This is another, I mean, my goodness, you can go to Walmart now and you can get your own self-installed alarm system. So is this an ordinance that we want to continue with? You get a lot of false alarms. I believe 911 dispatch, Daniel will come in and tell you that they probably get about one or two a week. We could be charging $25 a false alarm. That's money.
Go back and revisit, Mr. Bobby, your question about the schools. There's only 2 schools that we have debt service on. That's Glade Creek and Sparta School. Glade Creek runs out 24-25. Sparta runs out 32-33. So
High school is switched, it's back in their name now.
it's the only 2 remaining debt service schools that are on our schedule. Now, if you look at the property map and click on the link, it may not say that. I'm just telling you from the debt schedule perspective. Thoughts on
just,
that?
John's had time, he's picked out a few, I don't know how many ordinances that he's had time to go through and ask questions. This is, to me, this is news. I wasn't given these numbers that we'd be looking at today. And I don't, how many do you have, John?
Well, I've got about 6, 7 more that I think that we ought to have a department head review. There's a couple in here that I'm going to recommend that we consider canceling. I'll give you an example.
I just got one question that on this $15 fee. Does that apply to people who wear an emergency emblem that if they fall down or they have some kind of medical emergency and they send the alarm to whoever it goes to, it goes through these public lines, does that apply to them too? An elderly person?
Only if it's a false alarm.
What if they hit it by mistake? Now, you talk about false alarms, sometimes wind will shake a window or a building or something and set off an alarm. Now, that's a false alarm, but it was an act of God, I guess, because of the wind.
Right.
Chairman,
Yes, go ahead.
okay, he's got a list of how many?
I've got a few more. They're relatively simple.
What I was thinking was, okay, one of them we mentioned, we're not sure if statute makes us do certain things. I was wondering if we could get the list and let Heather look at the ones that may be tied back to a statute. And then we find out the ones, like some of these is some that the boards have made up. And then I guess that's the first thing, if we don't have anything that state says we have to do, then we can
Go over 'em and
go over
decide,
'em
yeah.
aside and say, okay, well, we've not done this for 40 years, so we don't even need this one, you know?
Well, we've got some common sense ones. Let me give you an example. The Alleghany County Civil Preparedness Agency. Now, we're going back to 1975 again. We don't even have a department named like that, but I feel that it needs to be reviewed by Daniel to see if it's applicable or if it needs to be changed. If it does, he can advise us on that. And this is what I'm trying to get at. We need to review. Here's another one. Ordinance for the regulation of fox hunting in Alleghany County, North Carolina. Last sentence. And I checked with Nathan Cox. People that are hunting fox in Alleghany County are using traps. Last sentence. No traps of any description may be used in the hunting of said foxes. So if you've got a fox that's getting in your hen house and you set a trap, you're in violation of an ordinance. But in the state of North Carolina, you can fox hunt it anytime you want. And that one was 7th of February, 1978.
Which commissioner signed that there? Perry did. They all.
Another example, an amendment to the ordinance to license installation contractors and others who install materials and equipment designated to meet the energy conservation standards of the state building code. Now we have an inspection department. Here again, we're going back, well, Leo Tompkins signed it, C.T. Doughton, 7 July 1978. A lot of these ordinances have been, there's no need for them right now. We have an ordinance that restricts the fishing off the low-water bridges. Evidently, there were two low-water bridges, State Road 1345 and State Road 1308. Have those bridges been replaced? And why do we have a restriction from fishing off two bridges whenever it's a danger on every bridge? Do we need that ordinance?
Suggestions? I think Timmy had one with a list.
I guess some of them, I don't see any others that may be tied back to statute, but I was just curious about if we literally do have a statute that says we got to do this or that. Even that being said, if we have a statute that's telling us we got to do that since 1975, it's not been a problem. But I agree with John that there probably is a lot of these things on these that probably does need to be removed. And I think if figure out how to move on from this, maybe like he said, there's one particular about Daniel looking at, see if there's anything that's got teeth. If not, then, we may need to get rid of it, remove it.
I will tell you, the ones that I read all these over the last week. Most of the most recent ordinances, there's no problem. It's these 50-year-old ordinances that go back. Here's another one. This is from 28th day of December, 1993. And this is, the tax shall be imposed on all motor vehicles as defined in General Statute 20-4.01. Boom, boom. The tax levy shall be annual registration tax of $10 on motor vehicles with tax status within the county. I think we ought to ask Rita to look at this, see if it still applies. If it still applies, are we collecting? I don't remember paying a vehicle tax the last time I renewed my licenses.
Everybody gets an annual, with their renewal of their registration. I wonder if that was incorporated into the tax based on the value of the vehicle instead of it just being $10.
Then that would have been a change in North Carolina statute. This no longer applies. We don't need to be listing it as a statute in the county.
In 93, I don't think we was getting charged a percentage tax on the vehicles. So I do remember the $10 thing. But yeah, now that's sort of a washed out thing.
Why do we have a ordinance that proposes a 180-day moratorium on the building of telecommunications towers in Alleghany County that was passed 5 March 2001, 23 years ago? And it was only for 180 days, but we listed as a ordinance that's still active. Surely to God, we can remove it.
I think we need copies of what he's picked out there, and possibly look at the ones that's been determined. Also, if there's some laws tied from the state statute, and let us look through those.
Are there any other ordinances outside of the ones on Commissioner John's list that you all have? I guess would be my question, because, and I don't mean this wrong, John, you don't take this the wrong way, but you're asking for a list comprised from one member.
Right.
So, are there any other commissioners that have concerns that we could add to that list?
I don't know if the commissioners have seen the list of ordinances.
I think we all just need to sit down and go through and look at it, then bring the list in. Yeah,
Printout list.
Yeah,
They can look on the internet.
I skimmed over it, but I did not go through, as you said, there was plenty pages of it. I didn't, maybe I didn't go back further enough back that far, but parts of them that I read, it's like it wasn't really any flags, but I don't think I went back to the 70s.
I agree with you. The most recent ones, they're pretty self-explanatory. I wonder why we still have an ordinance on the books for the financing of the moving of the library. I mean, that goes back 20 years.
It's probably been standard practice not to remove anything, just to leave it and not worry about it ever again. So, and one that might automatically be done after a certain period of time, we're not removing it, it's just not effective anymore.
We're not applying it.
I agree. I listed on the county website if it's overcome, if it's already exceeded. Moratorium for telecommunication towers. If I come to Alleghany County and I want to look at the county ordinances, and I'm looking at these, I'm going, Jesus, Mary and Joseph. It was for 180 days in 2001, and it's still on the books. Now, we can keep the records, but we shouldn't, I don't think that we need to list it on the county website.
Timmy, I think some of these, that you might actually have a little more input. I mean, Travis could too. Why would we need to have an ordinance in regards to regulating what John brought up for insulation? That's something that is inspected by the inspector's office.
Some of those things, back before 80, 81, we had no inspection office. And insulation, that's about all they came out and check because it was a county ordinance. You had somebody to come out and check insulation, And then I think Blue Ridge, Red Triplet, come out and check electric. Nothing else was checked, but the insulation, and I never knew why that was, but I think I know now because the county passed a rule on it. And they were checking
It references
insulation.
a North Carolina statute after the energy crisis in the early 70s.
I think at this point, that doesn't,
Gosh,
it
it's all-
doesn't make sense.
It's all voided now because we have state code that our county department, they follow in implementing new codes. So all that's just, it's,
But you don't have to have a license, though, to install it. You just are being inspected for what you did install.
no, now all that is sort of regulated by the state. So you got to have license to do certain things if you're a tradesman, like electrical, plumbing, heating, and AC. That has to be licensed, and of course, if you go over, now they've raised it to 40,000. If you're over 40,000 or more, then you got to have a license. So that's sort of regulated by the state. Of course, the county inspection people actually, they follow those guidelines too. So nothing in code like that, anything, we should not have any ordinance with that because that's all taken care of in that
State.
department.
But according to this ordinance, still on the books, we should be charging $25 once a year for anybody that puts in installation, and they've got to get a permit.
It's all covered by insurance on top of insurance. I mean, now you got liability insurance, and so everybody's covered and they're double covered, and so we don't need any of that kind of stuff.
So I agree that would make sense, that maybe we might pinpoint a few of
Some of the
these
easy
for,
ones.
maybe like Travis to look at, for Rita to look at, to say, does this make sense? We don't really have to do this anymore. And I think those would be some easy ones to get rid of, and one that might be out of date because it only had a specific time period, limitation of 180 days, which is well out of date. That makes sense. And I think certainly if the consensus is of the board that if these are out of date or old, that, they're not shown on the website anymore, I mean, maybe you can have an archive, where you have another drop-down little menu that says archived, and you might need to put on the side of it repealed or removed or something, so you still see it, but it's not there anymore.
And so,
Notation.
Right, but
A simple notation, ordinance no longer applicable due to general statute umpty-ump past 14 February. If we've got to keep them all and keep them listed, put that caveat in there, and then have an archive file where somebody could go back on the history.
I think that might clarify it a little bit also, instead of it just looking like it's still there.
some cases, just like we was talking about the building, it's covered, but it's covered in another way. Even though they had beginnings of the
Mr. Carter?
Just mentioning this, there are groups, and one in particular is called Municode. And Municode does a process of codifying local government ordinances. And I just looked, they have a gazillion that they do, and they do exactly what we're talking about. They review the statutes, they see if those things still apply. If we've got 70, for example, maybe a thought would be to reach out to one of these groups and just touch base with them and say, hey, we've got 70 ordinances, and I can pull up right now, for example, who they do in North Carolina, and it's a bunch. They do every state, just to be honest with you. But, we're talking about a lot of time spent right here. And, the list goes on down through here. I just went to the Wise. They do Yadkin County. I just happened to scroll down to the Wise. They do Yadkin County. So they're familiar. they could probably do what we're talking about in a much more efficient way, not to
Knowledgeable.
discard or disrespect anyone, but at least to reach out to them to see what their process is. Because we could sit here for the rest of the night talking about this stuff. But if we can reach out to, and I'm just using this group as an example, a group that does this service, they provide you, I used them in Virginia, they provide you with updated ordinances, they send them to you, you put them in your books. I mean, I don't mean this wrong, but I haven't seen an ordinance code book since I came here. And I'm used to that. I'm used to seeing an ordinance code book that has your ordinances listed, and anytime there's an amendment or a repeal or any change to them, in this example, you contact this company, you send them the motion or the identification of the board, they provide it, and then they send you the updated sheet. You tear out one, you put one in, and you have an updated code book from there on out. And if we have only got 70, our book's not going to be, yay thick, but still, we have that process in effect, and it saves Heather time, it saves department members time. Now, it's going to cost you some money. I'm not going to sit here and tell you it's cheaper or anything like that, but it's accurate, it's effective, and it provides not only the codes here, but these things go online. They're available everywhere. So we can sit here and talk about, every one you want to, but I want to throw that option out that there are groups that do this, make them conform to whatever the most current laws or statutes are, they're out there.
Fine with that.
Jimmy,
So am I.
Michelle,
Yes.
John,
Yes.
I'm fine with it.
So
So you reach out to
I'll
them
reach out to them.
and just report back when you get some information, because, if we take our department head time for them to go through, then it still has to go through Heather, for her to be sure everything's legal, then back to you and Heather back and forth. You're talking a lot of time. I just looked through here, there's 5 ordinances about solid waste disposable fees. I mean, there's a lot of stuff that may be redundant that we can do away with.
Reach out to them.
Thank you. Anything else on that?
No,
John?
I believe I've made my point that we did, we just need to review.
Tell you the truth, I didn't know we had 70 ordinances.
There's 70 of them, yeah. That's what's all
A
printed.
lot
right
of
here.
them
This is all
are
of them.
budget,
Delete.
a lot of
That's
them are
all of them
budget
in that.
modifications, things.
The only
that-
copy there is, I printed this last week. Supposed to be one.
Now, that's the way our residential, commercial building code, of course, they have started doing online now, but exactly what you say. When we first got our books, we had a binder, and then every year when they amended it, they would send you the new, you pop them up and you take out and you refill a page, so you have that constant change, and it was renewed every year.
And the more updated version, we talk about books and binders, which they still do, but they also send you that electronic format.
Correct.
Where you can put it on your website, and it's there, and it's got search engines, and you don't have to, no disrespect, but we're trying to match words with years to figure out which one to put on the screen. Well, you can do search engines on those things, and it's a whole lot easier.
We'll move on to the next item, rules of procedure, Mr. Carter, pages 2 through 11.
I think, if I remember correctly on this one, the conversation revolved around Robert's Rules of Order. I believe that when we were talking about this previously, I believe Commissioner John Irwin, you mentioned something that referenced Robert's Rules of Order for any type of disciplinary?
There is a section or a chapter, Chapter 62, under Robert's Rules of Order that gives the proper procedure for disciplinary action, and it gives a number of different scenarios. Now, our learned counsel has already modified our Code of Ethics for Board of Commissioners. The annex basically follows Chapter 62 of Robert's Rules of Order. And I believe that if we incorporate the annex in the rules of procedures, which would tell us how a disciplinary procedure should proceed, it covers the rights of the accused and things of that nature. I think that would be more equitable.
Which Rule 31 actually talks about Robert's Rules of Order.
Which, under the Code of Ethics or Rules of Procedure?
Rules of Procedure, that's the item we're on right now.
31, 32.
So basically, this Rule 31 is in part of this Code of Ethics has been added to? Or that we're just talking about rules of procedure?
Rules of Procedure.
But the only problem is the last two words, procedural questions. Disciplinary action, do you consider that a procedural questions?
If it is so identified, I would say yes. When I say that, I mean if a disciplinary action section is incorporated into the rules, then I would think that it would apply as a procedural,
Okay.
which we do not have. The section that you referenced in Robert's Rules do. If I heard you correctly.
And this body has been in violation whenever we censured Commissioner Walker. Chapter 62 states that there will be a committee formed to investigate the procedure, make a recommendation whether to proceed with disciplinary action or not, at which time there would be a hearing after a public announcement where the accused could have counsel ask questions. The same thing happened whenever the process was used against me. That's why I wanted it put in here a procedure for disciplinary action by this board. I'm satisfied with the annex that was placed in the Code of Ethics for the Board of Commissioners would satisfy that requirement by simply adding a paragraph saying for disciplinary action, Annex 1 applies, or a simple statement stating for disciplinary action, Robert's Rules of Order, Chapter 62 applies. You don't have to type all that out and get finger cramps.
I think the last time we discussed that, because unfortunately there isn't anything in the state statute that would allow for enforcement, it's just a process. The problem there, nobody really wanted to move forward with it. I think you can certainly discuss it again now. It's just a process, and I know that there was an emotion, but the problem is I think there's been one case on that, and that would be pretty cumbersome to try to enforce anything with, and it still doesn't have any teeth, because you're not doing anything to really censure the board member. So you could still put in place the procedure that Robert's Rules of Order does call for, and I think as long as the board is okay with doing that process, I don't see any problem with it. It just doesn't really lead to anything. The process then becomes cumbersome, because now you have to have a hearing, and you have to have evidence and witnesses, and it becomes like a mini trial in front of the board. And I don't know if everybody wants to do that or not. I mean, I understand it's now a process that would be standardized, that could be used. It's just a matter of, does everybody want to do that?
That is an opinion, depending on which side of the table you're sitting on. The accused or the accused?
Well, you either have a process and you follow it, or you don't.
And we go by Robert's Rules of Order, it is there.
So, as we all find, it's easier to talk about things that we agree on than the things we don't agree on. But, respectfully, I looked at, I guess this back, and I know we're trying to talk about procedure, but I was looking at, the things that's added to the rules, or the code of ethics at the back. And a couple things is that if we're not careful, we'll end up using our board to process disciplinary actions towards our the commissioners that do break the code of ethics rules. And I'm afraid that my concerns is there's one place in there that you advertise it in the paper, my understanding, and we don't want to do that. I mean, we don't want to go down that road. We don't want to embarrass our fellow members no more.
Did a good job last time.
But anyway, so and I've talked a little bit, I've thought a lot about it since the last meeting we had, and I think, and again, if Michael don't mind me throwing him on the bus, I'd actually bounced off on some ideas to him, and I thought we talked about and this is a proposal, this is not a have to, and it can be tweaked or whatever, and I was just wondering if maybe we could do a 3-strike system, because I do realize that we're all human beings, and the first time something happens, sometimes we have to do a better job biting our tongue than other, or actually tying our fingers up or something. But the point is, if we could figure out if there's something that comes up, and this is my thought process, and I know it's probably not a perfect process, but if an accusation comes up, if it's documented, in other words, somebody can't say, well, we had this conversation and he said this and I said that and this is what happened. Well, that's not documented. I mean, that's hearsay. But if there's something, whether it's social media, that can be documented, I was just wondering if it's a possibility that, first occurrence, whoever has been aggrieved or offended or whatever, whether it's a commissioner or a resident, and I know this might put more on the chairman, but possibly they could bring it to the chairman and say, look, here's what this one did or said, and it has to be documented. You can't just come in and accuse somebody without any kind of witnesses or anything. And and you find out that, and you decide, well, okay, this is probably one strike. Well, now how you get that to the rest of the board, or I ain't got all that figured out yet, but and if there's a second occurrence, a second strike. But I do think we need to be filled in, and the chairman needs to address it with that individual. Maybe a third strike, and then when you get to that point, if you do that, then possibly that's when you reprimand. And that's, again, it's just an idea. It's a thought process that, like I said, I understand, like, something happens to somebody says something offhand, or they get frustrated about it, aggravated, and we're all humans, and we can say things heated in a heated moment. You cannot, I understand that, and that's why I think it should be, like if something pops up, one occurrence, I don't think that's enough. But at the same time, I don't know any other way to do it, because, we don't want to put it in newspapers for 2 weeks, and you don't want to use up your meetings times, because we have a lot of stuff to do anyway, that you're actually having a trial on a commissioner. I just think that's going to be, way out past. I think if you did the 3-strike system, it wouldn't be so much, if you wouldn't have meetings or hearings on that first strike, second strike. It would basically be, I don't know if this is, I guess it could work, chairman, let's take to the chairman has a conversation with their commissioners, or, about that occasion, and it may end up being a situation where you really don't need to talk to commissioner unless you got documented proof, if you know what I'm saying.
Can I say something, Jimmy?
Yes.
On Facebook right now, put something on there about you, then go right 5 minutes later, so I've been hacked. You can't prove I put that on there.
And that's true.
Okay, that's all I've got to say.
How are you going to point that out?
Well, and I guess that's my,
This is where you have got to have an investigation so that the accused can give their side. I never was given an opportunity to give my side.
well, and that's the part, John, I said, if somebody brings an accusation about that to a chairman, it would be the chairman's place to call you up, have a meeting with you, just say, hey, here's what I've got. That would be your opportunity to explain your side of it. And, it could be, just like Greg said, it could be the case like, hey, I never did that. That was
I get a
somebody.
call on the chairman every once in a while. Who's going to confront him?
Well, that would,
I'm just saying.
it's a good question.
Yeah.
Me?
Vice Chair.
Yeah, vice
If I
chair.
get one on the chair and the vice chair, who's going to confront them?
Bill?
I was just saying that the vice chair would do that.
Whatever you want to do, you need to codify. You need to put it down so that there's no ambiguous thing.
Yeah, I
Yeah,
agree.
the chair confronted me, but he told me I would apologize in public or I would regret it. And I said, who do I apologize to? I didn't use the name. And then the next thing I know, the procedure was going through.
Well, I think the key is the chairman doesn't need to confront you. The chairman, in this case, will need to ask you questions about it to give you a chance to explain yourself. I think that's key, is it shouldn't be a situation where you're actually confronting each other.
I think the annex serves the purpose. It's very well written. It gives an opportunity for both sides to present their case and would fulfill basically what you've been speaking about.
It's just a longer process that we don't, what I don't agree with is that long, drawn-out process. If we could simplify it some way and make it shorter, I would be okay with that. But I think the Roberts rules, it goes a little bit too far in our situation, in our case.
I was going to bring that up, too.
Heather, go ahead.
Because you're either going to have a formal process or you don't have the formal process, you have an informal process. It's not really formal in the sense that it's not a legal process, it's just something that the board does. And if you want it to be a more informal process, then don't, don't follow the Roberts Rules of Order, you modify and make your own, and we modify what we've said so that it's not so formal. The ultimate outcome, no matter what you're saying, whether it's Robert's Rules of Order or whether it is your own process, none of it comes to any finality, which is a removal of any commissioner, any legal process where there's a court proceeding. It is just what you do either at a meeting, it is a public hearing, or otherwise. It never results in anything legal.
The long drawn-out process does not commence until a committee investigates and makes a recommendation to either proceed or other avenues. It isn't an automatic long proceeding. It is a recommendation of the committee if the rest of the board agrees to it. And you've got that in there.
I think, looking back, if I can say something here, on my situation, listen to the public comment, but, that's done at the next, all the facts. Hammering me right here in front of everybody. Are we going to take you off this right now? To, guilty verdict, let's hear some facts.
Go ahead, Michelle.
As a governing elected body, we are expected to behave in a certain manner. And we are expected to respect one another too. And, I think that a long, drawn-out, court proceeding process where it's printed in the paper and all the Robert's Rules of Order, I just think that turns it into a clown show. I think that as human beings, if we act accordingly to one another, and if I have a problem with Bobby, I'm going to go to Bobby and say, Bobby, this is what I heard, this is what I read, you need to knock it off, because we're expected to behave better than that. And then if he doesn't, then it's time to publicly bring it to the forefront and address the issue. Like Heather said, there's no recourse. There's no taking anybody off of the board. But to me, we're trying to complicate things too much in society in general. We just need to talk to each other like human beings and say, this is not becoming behavior of a commissioner because, and let's stop it here. And it saves all of us. It keeps our position elevated in the community. It shows unity, and it keeps us all in a professional standing. I'm not into embarrassing people, and I don't want to be embarrassed myself. Am I a human being and I do things wrongly? Yes, I do. We all do. But I think that that's the way to handle things person to person, is to go that route instead of having a whole bunch of rules about it and ordinances and, sheets of instructions to follow. Let's just keep this simple and be human to one another, is my suggestion.
Just a question for Heather, that, the board has no investigating authority. So if we start trying to verify or find out what went on, is there some recourse that somebody could come back and sue the board member for making a false accusation? If somebody takes you to court for slander because you said, this is what I found out talking to 2 people, 3 people. I mean, this is a two-way street that...
Your problem, though, is you're either going to keep this lengthy process or you're going to narrow it down into something that is a lot less complicated. It's either going to be Robert's Rules of Order, and that's kind of how this is written, or it's not going to be that, and you simplify it. But no, you don't have the authority to subpoena anybody to get documents or records. I mean, if it's not public that you can get your hands on it anyway, then you're just relying on somebody else telling you something. But, right, but if that is, if you decide that what you would like to have is a committee, and whoever sits on the committee to review anything in advance, and that doesn't become public, that's just something that you want to review for your own purposes to determine whether you have a conversation with one of the other commissioners about something that might have happened, then you simplify the process to say that that's what you're going to do. As I've said, no matter what you do, the ultimate outcome is there's nothing. I mean, but I do agree that if you decide you want to have some kind of process, you really should have something that you're going to follow so that it's standardized and you don't just willy-nilly every time something happens, now you do something different every time. You should come up with a standard, and if it's going to be a simplified standard, then fine, we figure that out and come up with something that is not like Section 6, where it goes into a lot of detail, and then there's an attachment schedule, or attachment A, that goes into real fine detail. You can simplify all of that, and kind of like what Timmy was saying, not necessarily 3 strikes you're out, but that you're keeping it between the commissioners, maybe in the committee, to have that conversation, you know? And I don't know if you want the chair to have the conversation first, or then the committee, or the committee, and then some kind of form of something there, but I do agree that it would be nice to have a standard that you knew you could rely on and fall back on instead of just coming up with stuff, you know. And I don't want to say it doesn't have to be as severe as, you know, the proposal has been presented, that attachment and the new part that I've added in Section 5. But you can go back over that and reduce it and simplify it a bit, so that you're not talking about a public hearing. Maybe that's a last resort if you're going to use it, and that would be at the end. You certainly could do it that way if you wanted, and then make a simplified process to begin with.
If the committee recommends no action, it's over with. The public would never
Right.
know it.
Right. And that would be
It would
internal.
be a conversation between the committee and the commissioners. And there's no requirement for the public to be notified unless there's a formal procedure.
Well, but it needs to be clarified then if that's the way that it's going to be handled, because that's not the way that it's not a committee. We would need to add that and say that it would be a committee and use that process first.
If we spell it out and they cross all those thresholds, then the end game is, this is what we'll do if that happens. So,
That makes sense, that it's an escalation of the process, which I think would be
So-
reasonable.
so that way, and I agree, there has to be a procedure, because I don't like to be put in that situation like this, if something pops up, and then you got to figure out what to do on the fly. So I just think it's better for us, it's better for future commissioners if they keep it the same way. Have something that we know that this is what's going to happen.
So I would suggest that maybe, maybe even Michael have a stab at it to adjust the language to have a simplified process to begin with. And I'm not really sure how you come up with a standard for it, but maybe you have a committee, as been discussed, maybe, and it's 3 board members instead of, 2.
That's the thing I couldn't figure out, because if you have a board member and you're talking to another board member, it's just 2 people, which I mean, as far as my concern, I trust everybody here, but the thing is, it's if you I didn't know how to fix that, like, if you have a conversation one-on-one, and then the one of them says, okay, here's what we come to, strike 1, strike 2, or whatever, so committee might be a good idea. And that's the point, that's what I said, and it's an idea, there's some things we probably need to tweak around it to make it better, You know, maybe some things take away from it, some things add to it, but it needs, it's a starting place.
There's nothing that says that the committee has to be made up of commissioners. I mean, the one thing that I look at, we have a retired judge. Judge Doughton could be appointed to a committee to do the investigation and make a recommendation. That's an outside party that doesn't have a,
So Heather, you are suggesting that possibly you and Michael get together and develop some type of language for us to look at on down the road?
Yeah, because I agree also, because of the ultimate outcome, it might make sense to have something that is a bit more an escalation, you know, so that you've got a process to follow, but it's not jumping right into a public hearing and this advertising thing and whatever. And take into consideration, and I've said this before, not a lot of counties have a process for this. It is very rare. And when the Code of Ethics was standardized and adopted by the state, it gave the option to add this in, but most counties and municipalities did not include it because there's no state statute to enforce. So most of them just left it off. There have been a few instances where there have been serious problems and people have been prosecuted, but that's because it was criminal activity. You know, so I agree, because this is such a huge step forward. Maybe you start out with something that's a little bit more minor to get your process going and have a procedure in place.
How long have we been working on this code of ethics?
Well, we go over it every year.
No, I just wondered.
You know, it's an annual thing to determine if there needs to be changes to it. This is just something we worked on at least twice, you know, in the last year, at least, maybe 3 times.
Sunset.
And it's a possibility, if we do get through and get some kind of outlay started and adopted, it's a possibility, if it's used, that we may see, or somebody may see down the road that, okay, we could do this and make that better. So we realize that, as you know, because I've actually talked to a couple county, just asking, picking their brain about stuff, and you're absolutely right. They don't even have it. They don't have any direction, no clue, nothing to do with that. So it's something new. So I do realize that it might not be perfect when they do get it fixed, but when you do get it worded, and if it's something that then from that.
This is an HR issue, and the way that you handle it generally in an HR manner is that you have a verbal warning, and then you have a written warning. So that could be the process that you go through.
the committee could recommend that.
I mean, if you write a commissioner up, we're gonna write him up for. We can't do nothing about it, what he done.
No, but
It's a process.
it's a process.
And then you have
Yeah.
something that's in writing that says, okay, well, something happens here, and you have a committee, and then they recommend that there be a verbal. Okay, well, then if it goes beyond that, now you have the committee that makes a recommendation, that now you have something written. I mean, it's either you have a process or you don't. And I think we figured out that we should have a process in place. Whether it results in any kind of something real or not, right, you still have a process in place, and then it's standard, and you know what to expect if there are problems, and you get it to the point where possibly that what we've got in writing now, which was proposed, that be your last resort, because then you do have a step in place. Regardless of what the outcome is, at least you have a process in place, and it's standardized, and you all understand what that would be.
Michael, comments?
That particular topic or the rest of the rules of procedure?
Procedure, yeah.
And I have some comments about the remaining items under the rules of procedure, but
You know, nowadays, social media has changed everything, the way that word gets out or people say something.
It's here forever.
Maybe it's time to look at something and see if it's something the board wants. But I always come back, people say, well, why do you let this go on? Why do you let that go on? Where does free speech stop and improper free speech? I mean, it's in the eyes or the ears of the beholder. You look at some of the demonstrations that are going on now, you know, they say some terrible things about people. And they say, well, I've got free speech. So I think you and Michael are going to talk, and at some point in time, you can get back to the board and report. Anything else?
He needs to, we've sort
He's
of,
wanting to go on.
we've sort of got
Yeah.
off, but at the same
Rules of
time, they're
procedure.
sort of they go
Yeah.
hand in hand, but there's some more things I think Michael's got on the rules of procedure.
The only thing that I want to point out about the rules of procedure is something, Bobby, you pointed out earlier on page, it starts on page 6 for the agenda. And we were talking about how this is a work session, not a formal meeting of the board. If you go and look at page 5 and 4, it defines the various meetings that the board can have. And if you look at page 6, when it talks about preparing an agenda, and you look at paragraph B, which was referenced, the agenda packet shall include the agenda document and proposed ordinance, etc. But that only applies to a regular, special, or emergency meeting. It doesn't apply to a work session. So we're in a work session. So when the question comes up about that, it specifically identifies meetings that are on pages 4 and 5 of your rules of procedure. It doesn't identify a work session or committee meetings. I just want to point that out, that in order to establish some parameters around work sessions, that paragraph needs to be changed to include such, and then you can include such parameters in your work session.
But that's a recommendation that you're making?
I mean, we've had a lot of work sessions lately, and with everything that's going on, I anticipate having work sessions, every month probably for a while. We have no, what I would call guidance for work sessions because they're not included in the section on agenda. If you want some guidance for how you conduct your work sessions, maybe I would recommend you incorporate that.
Michael has a valid point that, do you want to work on that and let us know how you want it worded?
I'll add it to the list. Yes, sir.
Is that agreeable?
Yeah.
Yep. That's the consensus of the board.
And we've already talked about Rule 25, how the confusion exists between all members and a majority. So unless somebody can tell me why it has to be all members, I think we change the wording
Majority.
to majority.
Just scratch through that.
With the exception of the agenda, or are you going to change that for the agenda too?
Well, that's what we need to talk about. I don't know why that rule in general was put in place. Because when you go to adopt the agenda each meeting, and if someone, for whatever reason, doesn't want something on the agenda and they vote against it, where are you? So I don't mean any disrespect to somebody that votes in the negative. I'm just pointing out the way that I understand how that rule came into play. It probably was used for a certain or a specific item, and here we keep following it. Why do we not have majorities on these things? Why does it take one person to stop the cart? No disrespect to that one person, but you know what? I live in a 3-2 world.
I was the last one to use it. My advantage. I would have lost if we'd have had a majority vote. I agree, it should be majority vote because you've got the arrogance of the minority on the agenda. I believe it should be changed to majority vote.
And there's a lot of time and effort that goes into making agendas, having people show up for items that are on the agenda, and they're all sitting in the audience, and we have one person that votes in the negative, and what are we going to do? I guess the chairman's going to call for a recess. If 4 of you and it's just one of you, I guess 4 of you are going to take the one out there and whatever you do to them. We haven't decided what we're going to do yet, but
That'd be good.
but you know, I just
Form a committee.
that hurts a lot of people outside the one that's throwing that rock in that manner.
I believe we have a consensus, Mr. Chair.
Change that, just those 2 words.
No, but it
Majority.
kind of throws it off a little bit. It'll have to, I think the whole paragraph will have to be reworded, because if you take that out of that one sentence, the rest of it doesn't make any sense.
Right.
So you have to reword the whole thing, I think, unfortunately. So, yeah, that'll come.
With Heather looking at the language of the whole thing, we're looking at those 2 words.
It's just my reminder.
New year, you're going to get some billable hours in, it sounds like.
That's
But I
all
think,
had.
I mean, ultimately, though, this is the opportunity to clean some of this up, to make it a little bit easier to either understand or to follow. So, you know, we might have skipped over some things before and not actually amended it or got off track or something. So I like this idea of going over it annually, because then there are things that, what if that doesn't make sense anymore, or whatever the purpose was that you came up with it at the time, it made sense, but now it doesn't make sense. You should be reviewing it on an annual basis. I think all of this stuff should be reviewed annually.
I don't ever consider this type of dialogue to be a problem. I don't consider it to be an add-on to responsibilities. I like having the board know what they're adopting, what they're talking about, I like that. I may give you some snide comment about adding it to the list or something, but that's out of respect. That's not out of disrespect.
Anything else?
On that.
And we'll move right along with the code of ethics, and
I think
we've been through
that.
and item number 4.
That item, we've talked about that in the budgeting process. We talked about that at the adoption of the budget. What that is there has been a continued discussion about having some type of audit provided on the fire department's due to the fire tax money going straight to them. That is not something that is included in your general audit. So we've talked with Robinson Farmer Cox, who is the current auditing firm that the county uses, if they could provide such a service, and they can. I think they've provided you with these sample, it's kind of funny if you read it, Mr. Smith in County of Sample, and if you're not careful, you get caught up thinking that's real, but those are just sample letters that they put together. But basically, they would go through and I think you've probably read it, they would pull a certain amount of the bills, and they would review the ins and outs and provide that service. And I think I'm safe to say that previously, when we talked about that during the budgeting process, everyone was supportive of that. And we actually talked about going about it alphabetically. We even got that far into the detail of taking maybe each fire department on a year-to-year basis, taking one and providing that, alphabetically, that service. And I think the cost for that is somewhere just shy of $7,000 is what that would cost the county to do it. Now, we're not voting on it, we're not doing any of that today, we're talking about it. But that seemed to be a favorable measure up until today, and I would imagine it still is, but, an example would be if you go alphabetically, I suppose you'd start with Cherry Lane. So for 1 year, you would cover the cost of, that type of audit for, in this case, Cherry Lane in the current budget. Next year, you'd move to the next one, and the next, and the next. And, that is a more feasible approach than trying to tackle all of them at one time. And your auditing firms probably couldn't do that because auditing firms are booked up. And when you throw 5 special audits on them, they're probably not going to have time for you. So that's kind of where we're at. They've gave you samples of how they do other localities. We, of course, could fine-tune that however you would like, but I'd like to have any kind of discussion about it. I'll certainly answer what I can, but I would like to put it on your next agenda because this year's running out. We're already in January. So,
Bill,
Well, I think that we owe it to the taxpayers to do this. I think this is an absolute necessity. I mean, we know that April, she runs a really tight ship and everything, but it's always good to have an outside firm audit tax dollars. I'm all in favor of it.
I think that is part of our fiduciary duties. I support it.
Yeah, I guess my question is, so the audit is focused only on taxpayer, our money that comes from the county. So, I guess, so all the other monies that they use, which I asked this question from a person that donates to our local fire department. Yeah, so that's not a legitimate thing to ask for, or it's not, to check into some of that, because, again, I asked that from an individual that donates money, and I don't want it to be a slush fund, if you know what I'm saying.
I do, and I'm trying to figure out the right way that I don't get my foot caught, but you're only responsible as a board for the fire tax
Right.
that you collect and provide to those departments.
Right.
Donations or other services or goods, I mean, you can certainly ask questions about them to the departments or bring it up to their respective boards, but as a commissioner or as a board, I can't say, I don't want to say it's none of your business. I don't want it to come out like that. I'm going to think of a creative way to say it. But you're only charged with looking out for the taxpayer funds that go into
As
it.
a commissioner,
Mhm.
that's all we're responsible for. As a resident, that's another subject.
Exactly
At
right.
another meeting.
So if they apply for a state grant and get it, don't go through the county, it's taxpayer.
The state grants would.
So this audit firm, where they look at the grant money,
As,
If it comes through the county, yeah.
oh, I mean, I think they can apply for a grant and get it themselves, can't they? Or is it all grants come through the county?
No, they
They
can.
do?
They
Okay.
can, they can apply themselves.
Oh, they can?
I think so.
And not even go through the county?
I think so.
Okay.
fire grants don't come through the county, and any citizen, by our IRS rule, any citizen can observe the books within a reasonable amount of time by request. They cannot deny them. If they do, their 501c3 is in jeopardy.
Grant thing, I guess the state, so if the state grants money, they have to show proof of that to the state,
State.
like they pay, correct?
Yes.
Yeah.
They have
So
their
that's-
own
That's sort of
audits.
their own audit situation.
Whenever the fire marshal does their inspection, they will look. They get a grant for $10,000, and they say they're going to be for pagers, there's got to be a bill for $10,000 for pagers, minimum.
But yeah, I'm all for the audit. I'm just curious about their, how they do that and everything, but.
With it.
So we'll put this on your next agenda for action then.
Be fine.
Okay.
Anything else?
About it for today.
We'll go ahead and close the work session, and we'll be back here in 17 minutes for
Wait,
a regular meeting.
Make it.
Thank you.
30 seconds.